So welcome everyone to this webinar on what is your life plan. I'm Melissa Rosenberg. I'm the Executive Director of the Howard County Autism Society. We've had a terrific response to this topic with over 100 individuals registered for tonight's session. We are recording the webinar. It will be posted on our website along with any materials provided by our presenters. And you'll get an email once that link is posted. We'll also be sending around a survey. We hope you will complete. It just takes 5 minutes. And since this will be a two-part session, one of the questions we ask is about a best date for part 2, whether that's during the week, in the evening, or what would be most convenient for you to attend. Thank you to everybody who submitted questions as you registered. We did share those with our presenters, and any other questions or comments can be put in the chat, and we'll be taking questions after all of our presenters present. I want to welcome our presenters this evening, thank them for their time and for sharing their knowledge with all of us. This is a very popular topic, and I want to introduce them to you. First up, I'm going to introduce everybody and then we'll go ahead and start on the presentations. Jim Curran and Monty Niddle from the Curran Niddle Group at Harbor Investment Advisors. Jim and Monty join us. They are certified financial planners who provide comprehensive financial planning and customized investment management for a variety of investors, business owners, and families. Jim and Monty have a specific focus on special needs financial planning and navigate their clients through the complexities of this process. Monty is the father of a daughter with special needs. And while Jim does not have a child with autism, he serves on the Howard County Autism Society Board of Directors. We have Kelly Nelson joining us tonight from Maryland Able. She's the Manager of Outreach and Communications. She's going to introduce the savings program to us tonight. Hopefully many of you are familiar and already participating. She wants to encourage and assist individuals and families in saving private funds which support individuals with disabilities to maintain health, independence, and quality of life. And then our final presenter will be Mary O'Byrne from O'Byrne Law. She has a passion for serving those in need. She began her career in the health insurance and managed care industries, but soon discovered she wanted most to help people rather than corporations. She's been doing this for over 20 years. She concentrates in estate and special needs planning, and she's a tireless advocate for the financial independence of people with disabilities. So with no further ado, I'm going to turn it over to Jim and Monty. Monty, I'm going to make you presenter here in just a minute, and then you can share your slides.
In the meet.
Behind you.
Over there.
There you are. Okay, you are now the host and you can share. Okay.
Okay. All right, there we go. So we all good now?
Very good.
Thank you.
Melissa, thank you for the introduction. And yes, we are, Monty and I are very serious about financial planning as the baseline for putting together your entire family's plan. It is a traditional financial planning, but with an extra element of it, which involves special needs. And with the fundamental question is, from a financial perspective, among many other things, what happens when we're no longer mom and dad are there to care for our son or daughter. So Melissa said, I don't have a child with special needs, but I did have a best friend who since passed that was 100% disabled with multiple sclerosis. Thus, in my helping him, actually I met Mary O'Byrne, and she helped us get things like trusts in place and things of that sort. So that's how I became acquainted with it, realized there was an entire community. There were very few people coming from my side of it, as in financial, that were servicing the community. So Monty and I came together and have partnered up and been together for 11 years. And Monty, if you want to just add anything to that.
No, I think you've done a good job, Jim.
Well, thank you. Let's go to the next page, or the first page, actually. All right, we're just to we're just to speak to an overview. So as I said, it's traditional financial planning with an extra element of special needs planning. Essentially, financial planning, we're looking at a family's resources. There's one nest egg. That nest egg has to serve many different objectives, listed here. Well, let me back it up. The primary objective, or one of the, the reason we're here tonight, is how are we, your family, going to fund a special needs trust, which will help your child preserve government benefits and live the lifestyle, the standard of living that you provided for them their entire lives. So there's one nest egg, but that nest egg has to serve a number of goals. If there's siblings, we're talking about, okay, college planning, 529 plans. How's that going to all play out? And then, of course, prior to mom and dad no longer being there to be available for the child, most people want to retire. So, that all of this is a holistic approach to, what.
Christy, do you know if they have a Wi-Fi here?
We good here?
Mm-hmm.
Okay, all right, then.
Okay.
Yeah.
Folks, please mute
That's okay.
yourselves. Please mute yourselves, please. Thank you.
Then we're going to cover letter of intent. Not everyone may know what that is, but it's a very specific narrative and set of facts about your child. Preserving government benefits above all things. We do not want to compromise those benefits that your child is entitled to. And then we talk about what kind of savings vehicles or do you have access to. Kelly Nelson is going to talk about ABLE accounts. Family dynamics, okay, that's where it can get kind of complicated or can run smoothly, but there's siblings involved, adult siblings, how involved are they going to be? What's the will going to look like? There's a lot of moving parts there. And then lastly, we're going to finish with giving you a homework assignment. And the homework assignment is something you can do immediately. You don't have to call anyone to set an appointment or anything like that. You can start that on your own. So Monty, if you want to take it from here.
Yeah, thanks, Jim. So I guess we both found it helpful to say what are kind of some of the major areas that you can help get you prepared. And obviously you want to move from red, meaning not go, to green, meaning go, meaning you're achieving your goals. So we've just kind of broken this down into 5 major areas. The first one, and really one of the most integral parts of the planning process, is making sure your child is eligible for government benefits. Sort of the key line in the sand, if you will, is, assuming that your child has it from a medical reasons is eligible. From a financial perspective, if they're under 18, they're considered, be eligible if the parents are eligible or not eligible. Most of our parents are not, have a car, have a house, would make them ineligible. Once a child hits 18, in the eyes of the government, they're considered an adult. So sort of the key litmus test is whether they have $2,000 or less. And that's in like a savings, a checking account. If it's an ABLE account or a college savings account, they don't count, they're not countable assets. So for the first item, if your child is currently receiving benefits or if they're under 18 and they have an appropriate diagnosis and they have less than $2,000 in their name, then you're good to go. You give yourself 2 points for that. If you kind of aren't sure whether maybe grandma or grandpa have something, or you really haven't, or you have assets kind of in their name, then that's clearly in the red. If they're under 18 and you're sort of ready to go, then that would be 1 point. The second item on the agenda is having a family financial plan. And Jim will talk about that on the next couple of slides. And that's really what it's doing is helping you understand what are your resources, what are your goals, and are you on track to achieve them? Or if you're not, what type of changes do you need to make? If you have an up-to-date plan and you feel very comfortable about that, that would be 2 points. If it's kind of in process, maybe you do a little bit on your own, aren't sure, speech educators here, give yourself 1 point. If you haven't started and just kind of have a vague sense, well, that's 0 points for now. The next major item up would be legal and estate planning, which Mary's going to talk about in a couple of moments. If mom and dad have updated wills, powers of attorneys, medical directives, and whether you've addressed whether a special needs trust is appropriate or not, and that's all taken care of, that's 2 points. You're kind of in the process, that's 1 point. And if you haven't started, well, that's okay. You're gonna get some great information to kind of get you going on that path. The next item is usually we ask for a show of hands, a little more challenging tonight in terms of, do you know what a letter of intent is? And typically, somewhere around a third to about 40% of the people understand what it is. We're going to explain to it in a couple minutes, and then Melissa also has a template that we set up that should be available. If not, just let us know. We can send you an email copy later this evening. So if you don't know what a letter of intent is, that's probably you're going to give yourself a 0. You know what one is, and you just kind of started or thinking about starting, that's okay. Give yourself a point for that. And if it's pretty much updated and completed, that's 2 points. So for those of us who've kind of gone through steps 1 through 4 and really put everything together, if you haven't communicated that plan to whoever's going to be sort of that future caregiver or caregivers as the case may be, it's really a lot of really hard work if it's going by the wayside. So real key is once you're going through the steps is to actually communicate the plan and then update the plan with those who are going to be the future caregivers as needed. So if you haven't started, that's a 0. If you're in the middle of it, it's a 1. If you're completed, it's 2. So you add it all up. If you're somewhere in that red zone, in that 0 to 3, that's okay. Hopefully we're going to give you enough pointers tonight to kind of help start getting you moving the ball. If you're sort of in that white zone, the 3 to 7 point range, it's a good job. This is a lot of work, and hopefully you'll get there. And for those who are already in the green zone, I think there's enough firepower tonight that hopefully we'll be able to move you along to help you get even more solidly over towards the 10.
Right. Monty and I put together a 4-step process that we think breaks it down into specific areas that allow for this to be doable. I mean, by the end of this, your head could be spinning because between Monty and I and Kelly and Mary, we're going to be covering, there's a lot of territory. And so one of the things is it's kind of a, when there's a mountain of things to get done, sometimes not much gets done. And it's, one bite at a time. And it does help to have an accountability partner, somebody that's going to just help nudge you along. It could be a family member, it could be a professional advisor, but everybody has very busy lives and a lot of stuff get put onto the desk with every intention of getting it done. But that's one of the big challenges, actually. So in terms of a holistic family financial plan, it's you want to, or with the help of a planner, identify who you are and what it is you're all about, and what you want to accomplish and what your real concerns are, and begin to speak to those things. And in the context of your child, their disabilities, what you want to ultimately be able to provide for them. And then if it's a larger family with a couple of siblings, how does that work? And, the obvious is, education funding. And then, mom and dad prior to, once all this, or as this all plays out, having to prepare for a retirement, because it's going to happen. And, and so it's a lot to it. It's a lot of moving parts. And from there, what you do is you're essentially stating your goals. And the goals might be that, we really would like to see our child living on their own in a safe setting. We do want our kids to go to college, and I do want to retire, and I'd like to retire at such and such an age. All right. And we want to maintain our standard of living. So that means one of our goals is to be able to continue at the same kind of income level that we are in our career years, working years. And, we have clients that, once their child with special needs is out of the system educationally and they're coming up on retirement, maybe they want to move to South Carolina or some other place. So, what you do is you start to articulate, okay, here's what I would like to do. All right. And then the next slide would tell you, okay, I've identified my goals. And so then the next item is, well, what do I have to work with, all right, to achieve those goals? And so that is simply an inventory of your assets and liabilities. And your assets meaning, what do I own? And your liabilities, what do I owe? All right. And assets minus liabilities equals your net worth. Another form of an asset or resource is Social Security. And if you're fortunate enough to have a pension. So then you want to look at, if you're in your working years, how much are you putting in your 401k? And then we're going to kind of examine, are you putting enough into your 401k? And then, articulate what those financial goals are. As such as I was noting, somebody might want to move, or they might want to put an addition on the house, or, any and all sorts of things. And so what we would have done so far is talk about our goals. What are the goals? What are the resources we have to achieve those goals? And what are the risks that could be an impediment to reaching those goals? And so from there, we do a stress test, you might say, that tests those three things: what I want to do, what do I have to do it, and in the face of the risks. And the risks being inflation, which is a front page item right now. And secondly would be longevity. Everybody's hanging around a lot longer than their grandparents did. All right. And then the most obvious risk is, stock market and bond market risk and such. So Monty, if you can go to that next page. So not going to get into details here, but it's just a quick little screen that shows, we're only going to look at these up at the top. There's this meter, you might say, that says 43%. And then there to the right of that, there's one that says 82%. All right. And so the software, which we utilize as a tool, after you've stated these goals and what you have to work with and what the risks are, will give us a reading on, are you in the place you need to be to achieve those goals? And so, for example, you might have said, well, I'd like to retire at 60 and I want to have this much retirement income. And so the software, it's a statistical probability analysis, says you got a 43. Well, you need or you should have a 75% to have a high rate of confidence in your plan. So, a planner might say to you, well, that idea about retiring at 60, you should maybe think about 66 and 6 months, your full Social Security benefit kicks in then. Or, maybe you should be putting more in your 401k to prepare for these days. And perhaps if you make those changes, you'll find yourself with a much higher probability of success, evidenced by that 82%. And so that's an exercise. It takes you from having a vague sense of where you are, meaning either the sinking feeling of I'm nowhere near where I am, or the rose-colored glasses place of, oh, I'm fine. And you really have never really measured if that's the case. So anyway, next slide, Monty, it's on to you.
Okay, so step 3 can be a stumbling block for a lot of people because it really does require some time. And really this key to it we're talking about is really breaking this down into digestible chunks so you can kind of get it done. A letter of intent, it's not a legal document, it's a planning document. And really it's about who your child is. I mean, I know with a lot of our children, one of the key challenges that face them is their ability to effectively communicate. And for those of us like in my case with my daughter who's nonverbal, it's especially challenging. So what the letter of intent does is it really provides a lot of key information about the care for your child. And also there's parts that really kind of go into who is your child and really elaborates on the type of care they're accustomed to receiving. It's a really great gift you can give your child. It is a lot of work to do, but it can get done. And you just need to kind of break it down into a process. So as we said, it's not a legal document. What you're really doing, think about this, is think about for a happy thought. Let's say you're going to go away for a weekend, you get some respite care, and Jim and I are going to be the ones providing the respite care. If we're coming into a situation like that, we really need to have all the vital information about your child in order to effectively deliver, the quality of care that they're accustomed to receiving. So a lot of things we want to put on here, not just kind of key people in their lives, whether it's school, adult, friends, family. We really do want to talk about some of the health issues, if there are health issues, if there's prescriptions, doctors, key things like that. If there's social needs, expanding it, whether they're therapists, whether they're legal contacts, whatever it might be, you really want to be very inclusive. And kind of as you go through this, you start really going through all this stuff and you think about in the future, you think, geez, there may not be one person in our life that really can tackle all the sort of quarterback, if you will, all of these issues. So you might kind of develop what we call a circle of trust. And really what that is it might be a small group or a larger group of people that are important in your child's life that are going to kind of help provide that level of care when you no longer are able to do so. And once you've gone through and done all these steps, it's really important not to just kind of put it in the drawer and say, got it checked off the list. It's a living document. It's about your child. And as we all know over the years, our children change dramatically over the years. So it's something that is either a life event or just as kind of a year passes, you want to update it. We've read in places, it makes a lot of sense to me that maybe around their birthdays, maybe that's when you want to kind of get the document out and update it as need be. So how do we go about taking care of this? We suggest breaking this into at least two parts. And really part one is really information gathering. So what you kind of want to do is maybe look through the document. One here is just a quick summary of the type of information you would need to get through, at least in the booklet that Jim and I put together. And again, if you need a copy, I think Melissa has some, Jim and I would also be happy to email you a copy. This is, if you get this information together, it's really get you through the first half of the letter of intent. In doing this over the years, we've had some great suggestions by parents, so for prescriptions, rather than have to write it down, especially if you're using electronic document, you can just take a little picture on the bottle of the prescription and just kind of insert that in the prescription section. It has the doctor, the dosing, and all the other vital pharmacy, all that vital information. So there's really all kind of neat little things you can do to personalize this so that it's effective in your life. So what we suggest doing is kind of looking over the document, assembling this information, and then go to the library, or heaven forbid things normalize again and everybody's out of the house and you have an hour or two at home by yourself where you can just kind of sit down and go through and get it done. And once you've got part one done, then maybe 2 weeks later, you go to tackle part two. And part two, again, you want to gather the information. The first part is really, again, a lot of sort of key information. You have, contact information, financial information, important documents. It's some things you might want to, if you don't want to put social security numbers or account numbers, that's okay. Just at least communicate, where do you have these documents so someone would have access to them if they need it. And part two is really thinking about your child. Again, Jim and I were coming in to provide respite care. We don't know what that daily routine looks like. We don't know if the things that your child likes to do, the things they don't like to do, if there's things that upset him or her or anything like that. So that's where you really kind of want to elaborate and make sure you can communicate, just how your child's accustomed to receiving care. And again, kind of once you get this all done, it's really important to kind of communicate this to the people who are going to be the future caregivers. So step 4 in the process, this again is going back where this is something where you probably need to get some assistance. It's really on the estate planning end of it. And Mary will really kind of go into a lot of the nuts and bolts on the right side of the estate planning. On the special needs side, you really want to make sure that you're maintaining eligibility for public benefits if your child isn't receiving those. And then obviously, some of the specific needs for your child down the road, do they need a special needs trust or not? If so, how does that need to be set up? Is guardianship, power of attorney, supported decision-making, what is sort of kind of the correct thing for you and your family? And kind of as you've gone through this step, again, it's, as you look to the bottom, you really realize that, mom and dad wear a lot of hats. If there's one parent, there's even more hats that individual is wearing, and as you think about the future care for your child, it might be a case where you need, a group of people that would kind of be involved to absorb the various responsibilities. And if that's the case, maybe you want to get everybody together once you've gotten their acceptance that this is something that they really do want to participate in, have them meet the team, go over sort of the roles and just make sure everybody's familiar with each other. Jim?
Yes. Well, at the top of the page, preserving government benefits. And by do no evil sort of means, the road to hell is paved with good intentions. It's easy to really make a mistake. And the mistake would be that your child comes into some money left perhaps by a well-meaning grandparent that puts them over that $2,000 amount. And that could compromise the government benefit. So it's been brought up, communication. And if a parent, grandparent has indicated they'd like to help the child, they have to have the information that it cannot be left to them as an individual, that as a trust, it would have to be left to them through a trust. So anyway, but it's important actually to get yourself up to speed, and in the system for any kind of government benefits. It's the gateway, SSI and Medicaid, to a whole host of other services, transportation, housing, et cetera. And so you do want to get yourself in the system, so to speak. SSI is available, but prior to age 18, but it is means tested. At age 18, your child would qualify for SSI. So Monty,
Okay, so the maximum benefit for SSI is $841. For those who've had children on it for a while, they got a nice little raise this year, thanks to that inflation thing Jim was talking about earlier. You may think to yourself, well, $841, that's not going to be enough money to kind of provide for the level of care and life that my child is currently living. Are there vehicles that we can save for that aren't going to jeopardize that? And the answer is yes. There's three major areas you can do it in, and this isn't choose A, B, or C. You can choose all three. It's whatever is appropriate for your family. So Kelly will talk more about able accounts. I'm not going to steal her thunder on that one. You can do a pooled trust. And pooled trusts are a type of special needs trust. The largest one in the sort of greater Baltimore, Washington area is the First Maryland Disability Trust. It's kind of a nice service. It's sort of one-stop shopping. They would go in. They would act as the trustee. They would do the investment management. They do the tax preparations, disbursements. It really is a viable alternative for a lot of people. If you want something that's a little more tailor-made, you can do a special needs trust. Mary will talk about these in more detail, but just real quickly, there's two broad types of special needs trust, and it's dependent upon how the trust is funded. A self-settled special needs trust means the individual themselves funded the trust. So for instance, if it's an adult that became disabled, like Jim's friend that he talked about earlier, that's an adult that had to move their assets into a special needs trust in order to then qualify for the government benefits. Or the other type of thing in doing the appropriate estate planning, mom, dad, grandparents, friends can put funds aside. In other words, a third party puts it in a trust, a special needs trust for the benefit of your son or daughter. And that's the other type of major type of special needs trust. And obviously, Mary will speak a little bit more about that.
All right, well, this just next slide is just really the intent is to make your head spin. Really just, in other words, there are so many, there's so much that has to be tended to, and it can be a little overwhelming. I mean, as you can see, everything from therapists to medical IEPs and, daycare, et cetera. And then on, the left side, on the right side, all the professional advisors, insurance folks and accountants, investment people, planners, attorneys. And then in the middle of that, you have all the family dynamics and, who's going to play a part in being there for my son or daughter when I'm no longer there, and to get all that sorted out. And it's not a simple, It's not that simple. Sometimes people make assumptions, and you don't want to make assumptions. You want to communicate to family members.
Yeah.
and such.
Come on.
The last item here for Monty and I, so we can have plenty of time for Mary and Kelly here, is a little bit of homework for you. Okay, so I'll preface it like this. Mary's going to talk about wills, and wills are what you leave behind that directs how your assets are going to be distributed. And so the beneficiaries are the recipient of the assets in the will. And one might be, but they'd be mistaken, thinking, oh, everything I have will be follow the direction of the will. Not true. All right. Anything that has anything to do with insurance has a named beneficiary. Okay. And by insurance, I mean life insurance, annuities, anything that has to do with a retirement plan, IRAs, 401ks, if you work for the government, 403bs, TSPs, if you work for the federal government, pensions, right? You name a beneficiary. And the custodian of these assets, the IRA or the 401k or such, they don't care what the will says. There's been a signed document that tells them who the beneficiary is. The will has no bearing whatsoever on how those assets are distributed. And often people's retirement assets are the biggest dollar amount of their savings are there. So what you need to do, here's your homework assignment. Go out, go back and find out who are the beneficiaries on all these different things you may have. And you might find there are folks named that you no longer want them to be the beneficiary, such as an ex-spouse, okay, from 3 jobs ago, a 401k that you may have had. And, so you need to go back there. The important thing is this: if you're married, you likely have your spouse as the primary beneficiary. But then if that person would predecease you, it goes to contingent beneficiaries. And you do not want your child with special needs to be named as a person in terms of being a ultimate contingent beneficiary. So if you have 3 children, you would have, son, daughter, and then not the son or daughter with the disability, but the special needs trust for the benefit of that child. And because once again, you could undo and compromise the government benefit. So that's your homework assignment. 401ks and such, a lot of them just, go online and you can do a beneficiary change there. But it's a little bit of effort, but it's something that you can do with immediately. Yeah, you don't have to call the attorney or the CPA or a planner or anyone like that. You just can get this done all on your own, and it's very important. So that's it from Monty and I, and we're gonna hand it over to Kelly right now. She'll talk about ABLE accounts.
Thank you, Jim and Monty. And all right. Hold on,
I stopped sharing. You should be okay now, Melissa.
I gotcha. Okay, now I need to make Kelly, I'm gonna make you the host.
All right.
And there you
How-
go.
How
All
are
right,
we doing? Are you able to see the slides that I put up?
not yet.
Oh, golly, here we go. Let's go.
That's all
Sometimes
right.
you can take it down and put it back up again. Let's just see here.
And just a reminder, go ahead. It's fine to put questions in the chat. We will address them at the end after Mary speaks. So we'll go back and circle back. So, and we will be sharing all the materials with you. Okay, now we can see you.
All right. Sometimes
Thank
it
you.
just likes me to take it down and put it up again. I don't know.
That's right.
Yes, well, thank you so much for having me tonight. I am, as Melissa mentioned, Kelly Nelson. I'm the Outreach and Communications Manager for Maryland ABLE. But I always like to share with people that attend the presentations that in addition to working for Maryland ABLE, I also have some practical real life experience with using an ABLE account. I am a parent of a 17-year-old daughter with multiple disabilities, and I serve as the authorized legal representative to help my daughter Lily manage her account. So I've had the opportunity to see how an ABLE account has really helped her to build her some independence and some financial literacy skills, but also as parents, it's helped her father and I to be able to begin in this extraordinarily big, elephant in the room responsibility of planning for our daughter after we're no longer here. And we certainly hope that we're here for decades to come, but I also know that we have to begin somewhere. So Monty and Jim did a really great job in sharing a lot of information. And one of the things I want to pick up on is something that they said, that we need to make sure that as we're planning and preparing for the future, that we're doing so in a way that we make sure that there are no assets in our children's names that would cause them to lose those federal and state means tested benefits. So this is where ABLE accounts really come into play. So that's what we're going to talk about. I put my name and contact information in the chat because I'm going to be giving you a very bird's eye view of ABLE. Normally I would have about an hour to share all this. So what I'm going to do is hit the main highlights here. Basically, ABLE accounts are available through federal legislation that was passed in 2014 that finally gave people with disabilities the opportunity to save and invest without jeopardizing those state and means tested benefits. So for a long time, people weren't able to save their money. They were spending it down only to find out that they needed a little while later. So let's look at some of the main reasons people choose an ABLE account as one of their tools in planning for the future. The first is that it increases that savings limit before SSI cash benefits are impacted. I'm not sure if it was Jim or Monty talking about that $2,000 limit that is associated with folks receiving the SSI cash benefit. So any money over that $2,000 limit that's held in a regular bank account, a checking or a savings or anything like that, could jeopardize their benefits. And not only would they lose the SSI cash benefits, but they would also lose the Medicaid that usually comes with it at the same time. So we have a couple of tools that we know that we can use that are asset protection tools. One of them is a special needs trust, and they touched on that a little bit. I'm sure Mary will be sharing a little bit more about that, but I'm going to focus now on ABLE. So with ABLE, it raises that savings limit from only being able to have $2,000 in the beneficiary's name to now being able to have up to $100,000 in an ABLE account before it impacts those SSI cash benefits, okay? So not only does it protect the SSI, but it also protects other state and means tested benefits, federal means tested benefits, things like Medicaid and Medicaid waivers for food, housing, and energy assistance. So now we're able to save up to $100,000 in the account and maintain those benefits. So that's really the main reason why people choose ABLE accounts as a tool. There's some other great benefits in that there is no federal or state taxes on the earnings while the funds are in the ABLE account, and not when they're withdrawn, provided that they are used for what we call qualified disability expenses. I'm going to show a little highlight of that in just a few minutes. Here in Maryland, ABLE account holders and beneficiaries have access to a Maryland state income deduction up to $2,500 per beneficiary per ABLE account. So this is only going to apply to Maryland state taxes. So, anyone can contribute to an ABLE account, which is a wonderful thing. But if grandma lives in Florida and she contributes to your son or daughter's ABLE account, that's fine, but she's not going to be able to take advantage of that income deduction because she doesn't pay Maryland state taxes. But for families that mom and dad that are married and filing joint are able to claim up to $5,000 as an income deduction if they contributed that amount of money to the ABLE account. So there's an incentive to help us parents as we begin to plan and put money away for our child's future, which I think is nice as well. The other benefit is that it offers easy online enrollment. We've all been through this process of having to fill out very lengthy forms and waiting a long time to see if we're approved. But with an ABLE account, you register, you can enroll on it. You can enroll in it online directly from our website. And it takes about I'd say 15, 20 minutes if you're opening it for someone under the age of 18, a little longer if we have an account we're opening for someone that is over the age of 18. And I'll explain that to you in a little bit. And there's easy access to funds. You know, this is a situation where the person who is the beneficiary, the account holder, the person with the disability, right, is able to have access to their funds through a prepaid card and some other functions. So that really provides a great opportunity for some financial literacy skills, learning some budgeting skills. Real quick, most of you are familiar, I believe, with the criteria for enrollment is that you had to have the onset of the disability prior to the 26th birthday, and that you have to have a disability that meets the Social Security Administration's definition of a disability. And this can be determined one of two ways. When you're enrolling in an ABLE account, it's going to ask you, are you currently receiving SSI or SSDI? If the answer is yes, you click that button, yes, and you get to skip ahead a little down in the process. But it's okay. You know, if you have a family member that's currently not receiving SSI, we have access to forms on our website. It's called a disability certification form. You would download that form, take it to your family member's physician, and have that person check off the disability code and sign it, and you would just maintain that in case you were ever asked for it in the future. So that's one of our big myths, is that you have to be receiving SSI to open an ABLE account, and that's not the case. We do know that for many folks that have disabilities, my daughter included, don't receive SSI prior to turning 18 because they're looking at Social Security is examining the entire family's income, and that oftentimes disqualifies them. But when the child turns 18, then they're looking at just that individual's income. We do know that ABLE accounts are both owned and managed by the person with the disability. They're the owner and the beneficiary of the account. We do realize that there are some ABLE account holders who need assistance. These are financial accounts, and for whatever reason, they may need assistance. We do have someone that can serve in that role to support them. That's called the authorized legal representative. If your family member's under the age of 18, an adult is going to have to serve in that role because they're not able to have a financial accounts as a minor. So if they're over the age of 18, we need to have consent from the person with the disability saying, yes, I would like this family member or this person to serve as my ILR. And that could be provided. That can be done by providing a copy of your power of attorney, or if there's guardianship papers involved, or there's actually a form on our website that you can take to a notary and have a limited power of attorney over the ABLE account only. So those are some options for that. When we talk about contributions, anyone can contribute to an ABLE account. I do want to share with you that we've had a very wonderful update here in 2022, and that is our standard annual contribution limit has increased to $16,000. Last year it was $15,000. This amount is tied to the federal gift tax law, and when this law changes, saying that people can give gifts for up to X amount without paying taxes, this is going to impact the standard annual contribution limit for ABLE accounts. So good news is there's more opportunities to save in 2022, thanks to that increase in the gift tax exclusion law. We also know that folks that have ABLE accounts who are working and who are not currently contributing to a retirement account, or their employer is not contributing to their retirement account, can contribute an additional amount of money to the ABLE account. It is going to be limited to $12,880, but it's also going to be limited by the maximum amount of money that the person earns, okay? So if they're making $5,000 a year and wanted to contribute it to Able to Work contributions, they could do so. If they got a full-time job and years down, a couple years down the road, they're making $15,000 a year, they're still going to be limited to that contribution limit for Able to Work, which this year is $12,880. Here we see that $100,000 account balance that is associated with ABLE accounts. And I know that Jim and Monty had talked about that a little bit. Here's what would happen if someone has an ABLE account and the balance were to go beyond $100,000. What would happen is Social Security would put the cash benefits into a state of suspension. Notice I said suspension and you're not being disenrolled. So you go into a state of suspension, but the Medicaid and Medicaid waivers remain in place. And that is a very important piece because money outside of an ABLE account jeopardize SSI and Medicaid. Money within an ABLE account beyond that $100,000 limit would cause a state of suspension on those cash benefits, but Medicaid remains. And at any point you were to spend the money down and the balance falls below 100,000, Social Security is able to reactivate those benefits, okay? All right, so one of the things I do want to point out about this $16,000 a year annual contribution limit, for those of you who are really good thinkers and financially savvy, and you're thinking to yourself, well, gosh, Kelly, $16,000 a year is not very much for me to be able to save or invest for my family member and have that be enough money for them to live off of when we're gone. And that is true. And that's where we see a need for multiple tools. So a special needs trust is something that is also an asset protection account that you can put in large amounts of money. There is no limit on the amount of money you can put into a special needs trust. All right, I am going to make the slide deck available to you so you guys can go back and reread the information about eligibility for able to work contributions. We do want to let you know that if you have a 529 college savings plan, and maybe your son or daughter is not going to be pursuing a traditional college path, you can roll that money into an ABLE account. It's still subject to that annual contribution limit of this year, $16,000 a year, but then you're able to use the money for education. Still, you can use it for education, college, books, dorms, room and board, but you're also able to use it for a lot of other qualified disability expenses. Definitely don't have time to get into all of the savings and investment options available through an ABLE account, but I do want to let you know that we do have a cash savings option, which is an FDIC insured banking product that earns the federal interest rate, which is very low at this point. We also have 4 investment options. That's new in 2022 as well. We've added a 4th investment choice, and that's our fixed income. So I'd love for you guys to visit our website and learn a little bit more about that new option we have for you. When it comes to contributions, anyone can contribute to an ABLE account. It's important to know that funds can come from any source. It can be from family and friends, could be from earned income. A lot of folks chose to put their economic stimulus payment into the ABLE account because they could access it whenever they wanted it, but also leave what they wanted for the future as well. You can put back payments. Sometimes we see people get back payments from SSI or DDA or whatnot, and small inheritances and settlements. But again, like Jim and Monty warned, make sure you do not have your child as the beneficiary on anyone's life insurance policy, because that can really mucky the waters. When the money's in the ABLE account, you have the opportunity to use it for anything that supports the beneficiary in his or her health, independence, or quality of life. And these topic areas here are just meant to be that, just topic areas. This is not an all-inclusive list, but as you can see, there's a lot of things you can use it for. Health prevention and wellness could be doctor pay, co-pays and prescriptions, but it could also be a gym membership. It could be therapeutic riding lessons. I mean, there's all kinds. You have to kind of just ask yourself, does this expense, does this purchase support my son or daughter in his health, independence, or quality of life? And that is how you determine whether something's a QDE. One of the things that I do want to say here is that this is a question that did come up. People say, what happens to the money in the ABLE account when the person passes away? And as you can see on this slide, we do have, you are able to use the funds for final expenses, funeral and burial expenses, things like that. After that, you can use the account to pay off any other outstanding debts. After that point, the money that is in the ABLE account, if they have a family member, a sibling, okay, that is eligible for an ABLE account. They can roll the money over to the ABLE account, but let's just say they don't have a sibling or a family messed up sibling that has an ABLE account. That money becomes part of their estate. So the way it works is that family members, you know, and it just, and Mary could probably explain more of this to you, but it's sort of a hierarchy. They look at, is there a spouse? Is not, is there a child? Is there a parent? Is there a sibling? You know, so it kind of goes down that way. People could liquidate the funds that are in the ABLE account and have that money. But remember, these are special savings accounts intended only for the person with a disability. So they will be paying taxes now on the earnings. Okay, so some tax implications. ABLE accounts are online accounts, so you're going to link it to an existing account. There is no Bank of Maryland ABLE or Bank of ABLE in general, so they are all intended to be online accounts. We've got some other features, just don't have time to get into all those tonight, but the prepaid card option is a very convenient way for people to access the funds in the account, and has
Excuse
been
me, Kelly, just a minute. I just want to make sure, please make sure you're muted so we can hear Kelly. Make sure, especially if you're on the phone, make sure you are muted. I'm hearing a lot of feedback.
Oh, thank you.
Thank you. Go ahead, Kelly.
So the prepaid card has been a very helpful tool in budgeting, saving, and spending habits. It gives the person the ability to use the card in the community and online. So lots of good things coming out of that. That does not come with the Maryland ABLE account. You have to opt into it. And there is an additional fee to have the card. It's $1.25 a month. So just, you know, if it's something that you think you would like, it is something you can opt into. We have a gifting page, which has been a great way for people to support ABLE account beneficiaries in their savings goals. Actually, we have 373 people out of our over 4,000 ABLE account holders here in Maryland that have activated their gift page, and over the last 3.5 years have collectively received over $2.5 million in gifts. Okay, so people do use this, and it's been very helpful in supporting them in their goals, in their saving goals. We mentioned the tax incentive here in Maryland. For anyone that contributes to an ABLE account can use that as an income deduction on their taxes, as long as they're paying Maryland state taxes. There is a fee to have an ABLE account. It's $35 a year. And there's also going to be some asset-based fees if you choose an investment option. And you'll want to check our program disclosure book for that, because they're all different based upon the investment portfolio you choose. So to enroll in an ABLE account, you can do it directly from our website. At our website, you can access our program disclosure booklet, which will tell you everything in detail about the ABLE account. Frequently asked questions are there, and any forms that you might need, like that limited power of attorney or the disability certification form that I talked about. Okay. That's going to be it for me tonight. I put my contact information in there, and I thank you very much for having me, and I'm sticking around for questions.
Thank you, Kelly. If you can return the host, thank you. Unshare, there we go. And just a reminder, please make sure that you are muted. Once I turn the screen over to the presenter, then I cannot mute you. So just please remember. And so now I'm gonna turn it over to Mary. And I know it's a lot of information. Please know we're gonna share all the slides, all the information, contact info following the session. Might not be tonight, but we will get all that to you, and it will be on our website. So Mary, I am making you the host, and you can go ahead and share your screen. And then following Mary's presentation, we will have Q&A. Okay, thank you.
All right. Well, it's really a delight to be on the same panel with Jim Curran and Monty Niddle and Kelly Nelson, because they all are so knowledgeable about what they're here to share with you, and it's also, I just say, so exciting to see the growth of the ABLE program over the last 4 to 5 years. It's really heartening. I want to say thanks very much to the Howard County Autism Society and to Melissa for inviting us to be present. And I'm getting serious feedback there. I want to start by giving you a picture of sort of how we as special needs planning attorneys work with families and help to plan for a healthy and prosperous future for their child with disabilities. And we found that this graphic is kind of a helpful way to be able to show the ways that different aspects of planning interrelate. My discussion in the remaining time tonight is going to be on the right side of the screen around estate planning and assisting decision making. But as you've already heard from Monty and Jim and Kelly, a lot of this planning is around maintaining eligibility for public benefits like SSI and Medicaid waiver programs in the goal of achieving a good life, of having a healthy, being part of a healthy community, of having a safe and secure home, a sanctuary that someone can return to have meaningful activity and work every day, and to experience the support of friends and family and others. So I'm hopeful that this graphic is something that will be sort of useful as you envision your planning in the future. And like Kelly said, there's a few more slides here than we're going to have time to talk about, but we like to kind of pack stuff in here so that when you come back and look over your notes and reflect on the discussion tonight, you got some other resources. So as Jim and Monty have spoken about quite a bit, the notion of estate planning is an important part of laying the groundwork for that good life in the future for your child. And estate planning is one of those terms that sounds like that's only for rich people. Only rich people do estate planning. That's not so. We all need to think about planning around how we want to leave what we have for the benefit of others when we die, but also importantly, thinking about what if during our own lifetime, we might need help in decision making for ourselves. You know, if we became sick, if we had an accident, to make sure that we have tools in place to have a legal way for other people to step in and help us if we need that. And so many of the planning notions that we think of for our children with disabilities are important for us too. And as Jim and Monty said very clearly, you know, this planning for the family as a whole, it might be, you know, the surviving spouse or other family members. It might be planning for a blended family. You know, we always have to plan for taxes. And so there are important aspects about planning, particularly that can be beneficial for individuals with disabilities that can get sort of better tax treatment in many circumstances. And right in the middle of this slide is the line that says naming the right fiduciaries, which is a fancy word for the people who are in charge of the money, people who are going to be in charge of looking after the wealth that you leave in trust for your child with disabilities. That might be actual money like cash, it might be retirement accounts, it might be a home, but it's people who are in charge of looking after assets for the benefit of others. Those are fiduciaries. And as we're going to see, that's often the toughest choice we have to make. Just a couple of minutes for definitions, okay? What's a will, what's a trust, what's probate? We're going to hit this pretty quickly. And so a will is a legal document that has kind of a limited purpose in life, and that purpose arises when you die. A will is a document that is meaningful, most meaningful when you die, and it sort of has its 15 minutes of fame. It's subject to rules in state law, which lawyers are experienced generally in making sure are followed. And a will is used to give instruction about how somebody's probate estate is handled when you die. We're going to come back to probate in a second. Jim and Monty made a reference to this. It also importantly appoints the people or the entities who are going to carry out your instructions. Very important for people who have a minor child, whether or not that child has a disability. The parent's will is the place where you give instruction about who you want to be your child's guardian if you die while you leave minor children. So will is very important in our planning, but it is, think of it as a document. It's just that. A trust, on the other hand, while it starts in a written document, a trust is actually, it's like a living thing. It's a legal entity that is created for the benefit of certain individuals and with instructions to the person responsible for managing it, and that's the trustee. That person, it might be a bank, it might be a person, it might be, people in, working together, but the trustee is kind of the manager. And the notion of a trust is something that's going to be around a long time. It's going to, in planning for a child with disabilities, this is a trust we expect it's going to be around for the child's lifetime. So going back to that notion of a will is a document that sort of has its moment in the sun. A trust is a document that's going to last a long time. It creates a relationship and responsibilities, and that looking towards that sort of longer term is important in our planning. There's a lot of different types of trusts sort of available in our legal system. We're really focused on special needs trusts, okay? And just by the way, probate. Probate gets such a bad name in the press these days. Lots of people advocate for how important it is to avoid probate. But probate essentially is a process that is conducted through the orphans court in each county or the city of Baltimore. And it does a couple of very specific things. It validates your will as being, proper, your will. That document is properly executed and meets all of the state law requirements. Probate involves collecting and valuing those assets that are just in your name alone when you die, and following the instructions to pay debts or taxes and then distribute those remaining assets out to the people who are named either in a will or who are your legal heirs. And very importantly, as we heard before, not everything we have goes through probate. And that's really important to remember, because your will only controls the probate part of the picture. Your will doesn't control things that pass by beneficiary designation, like insurance or retirement accounts. It doesn't control how things pass out of a trust. And it doesn't control things that are jointly owned. So it's important to realize that your will is a big part of your planning picture, but it's not the whole picture. Often people ask, well, what happens if I die without a will? Well, you may still have a probate estate if you left assets that are in your name alone when you die. And if you do leave probate assets when you die, we have a list of who gets what and in what percentages in our state law. It's kind of like the default estate plan if you don't have a will. And things will pass to people by familial relationship, spouse, children, parents, or more remote relatives. And we really don't want anybody to pass without a will, but especially we don't want parents of individuals with disabilities to die without a will, because we really want to be sure we've got the planning in place to avoid assets being inherited by someone who's receiving SSI or Medicaid, which they would receive outright potentially if there was no will that directed things into a trust. So I keep talking about trust, so now we're going to get into that in a little bit. And I just want to focus on 3 key points just to start this discussion. There are many variables in how a trust can be established, how flexible it is, when it comes into effect, when it's funded, a lot of variables of that nature. But when we're talking about special needs trust, I want us all to focus first on the purpose of the trust, because despite the variables, the purposes are all the same. And then the variations have more to do with what your personal circumstances are in terms of the kinds of assets that you have, when you might want these things to go into the trust, and how you want to leave those instructions. So the general concept of a special needs trust, I think you're probably all pretty much on board with this. It's a way to set aside assets that might be money, it might be stocks and bonds, it might be retirement accounts, it might be real property, and so forth. Special needs trusts are a way to set those aside so that they can be managed for the benefit of an individual with disabilities, both to protect those assets and ensure that they're not subject to other people trying to manipulate them or to fritter them away, but also to do it in a way so as to protect those assets so that they don't count towards those terribly low resource limits for SSI and Medicaid, that $2,000. Some other programs may have a little bit higher limit, but we're mostly looking at that $2,000 resource limit. And that number hasn't changed since the 1980s. It hasn't been adjusted for inflation like so many other things. And by the way, which is going up, right? That $2,000 resource limit has been around for a long time. And the special needs trust and the ABLE accounts help us to kind of get around that. I think of that as the green ceiling of that low resource limit. When I said that there are variables in trusts, I want to expand on that a little bit. When we talk about a special needs trust, we want to think first about whose money or other assets are going into it. If those are assets that belong to the individual themselves, the individual with disabilities, maybe they received an inheritance that wasn't planned for. Maybe they had an injury and received a settlement or a jury award. Maybe their earnings have accumulated and they're at risk of exceeding their resource limit. Maybe they got the winning ticket in the lottery. And all sorts of ways that someone may have assets of their own that might jeopardize their eligibility for benefits. For them, we're looking at a first party special needs trust. That's the terminology we use. If somebody else's assets are going into the special needs trust, mom, dad, friends, neighbors, great Aunt Tilly, that's a third party trust. That's somebody else's assets that are going into the trust. And that's a really important distinction in our planning because the rules are different for those. One of the other questions we look at is, do we want to set this trust up today? Do we want to have this vehicle here for others to contribute to, for example? So maybe we want to set something up during your lifetime, even though you think that, well, things may be contributed by others, or you may expect that it's going to be funded later in life, but you want to have that vehicle. You want that bucket there to be sure that there's something in place. We call that a living trust or an inter vivos trust. A trust that's established at your death under your will is one that we call a testamentary trust because it's in your last will and testament. Okay. Another really important feature that we talk with clients about is how much flexibility do you want to have with this trust? Do you want to be able to change it over time? A really good idea when you're planning for the lifetime of a young person, being able to go back and make changes to this trust over time can be really helpful. You might want to change the trustee in the future. You might want to change any number of things. So that flexibility is really helpful. Using a trust that's revocable or revocable, depending on your pronunciation, that is a very flexible kind of trust because that allows you to go into to change it over time. An irrevocable trust is one that, as you could imagine, you can't do that. An irrevocable trust is one that you can't change. And which type of special needs trust, first or third party trust, during your lifetime, only at your death, revocable, irrevocable, those kinds of variables will depend on your circumstances, your planning goals, and how you envision funding these trusts over time. But for all of these variations, the core is the same. These are all variations on a special needs trust, hold and protect assets for the benefit of someone with disabilities to ensure that these funds are not counted or don't otherwise interfere with public benefits. I just spoke about that, so we'll skip on. So here's some examples. It's a very common model. Parents put a trust under their last will and testament, and that's a testamentary trust. It's going to be funded with probate assets, but also can be funded from things outside the probate process. Sometimes we work with grandparents who want to set up a trust for a grandchild. They want other people to be able to contribute it, but they don't want anybody to be able to change it. Well, then they're probably looking at an irrevocable trust because they want to be sure that nobody can tinker with it later on. Very frequently, parents that we work with want to put in place a revocable trust so that they can respond to changes as their child matures, as the environment may change in terms of tax laws or benefits laws, as the relationship with people they've named with trustees or possibly future beneficiaries after their child has died. Those are all examples that will lead us to a revocable trust. And if we have an individual who, for instance, who might be on SSI and receives an inheritance, then we're going to look at using either an ABLE account, depending on the amount of money we have, or potentially a first party special needs trust. You know, all those variables may sound confusing, and if so, it's because I didn't explain them very well. But you know, those are really things that an attorney can help you pretty quickly work through to help figure out how, you know, what sort of model of a special needs trust works for you. The really tough question comes when you're selecting trustees. That's the hard part, because we want so much from these people or these, you know, banks or other organizations who might be a trustee, because this is who you are trusting to manage the wealth you're going to leave for the benefit of your child over their lifetime, and in particular when you're gone. And like we want everything from our trustee. We want them to be patient. We want them to be good advocates. We sure as heck want them to be honest and concerned about the well-being of our child. We'd like, you know, them to be a good investment manager. You know, I'm showing my age when I'm going to have to update this slide. I don't know how many people here by a show of hands know who George Burns is, but he was a vaudeville and comedic actor in the movies who lived over 100 years old. That's the longevity joke. As we think about choosing the trustee or trustees plural, we have these great expectations of what their role is going to be. And this is where it really is important to talk with those people who you think you want to name. That might be other family members. It might be other adult children. It might be your own siblings. It might be nieces and nephews. And again, it might change over time. But it's really important to talk with those folks about, you know, are they willing to do it, and help them to understand the job, and to help to begin to help them to begin to understand what their responsibilities might be. It's also important to consider building in, you know, those who may have the authority to change or to remove a trustee. If we were to run out of the people who are named, we always want to have a backup provision so that we can find someone else to serve as the trustee. It's also important to think about what the cost of the trustee services might be. This is particularly relevant if you might be looking to a bank or another sort of institution to be a trustee over time, because this is a job, and whether an individual or a business that serves as trustee is entitled to be paid. And it's important to think about how that happens and what that cost might be. A very important role that has become much more popular in the last decade or so is that of what we call a trust protector. It's most helpful to think about this is someone who is named in a trust to be an advocate for the beneficiary, particularly for a beneficiary who may not be able to advocate effectively for himself or herself. This is someone who you can name in a trust, who at some point in the future, for instance, when the parents have passed away, would have the authority to do a couple of things. You know, it's not a substitute for the trustee. They're not investing the funds. They're not managing all of the uses of the funds, but it's a role for somebody who can look over the shoulder of the trustee and make sure that they're really looking out for the beneficiary. So the trust protector is permitted to get an accounting, and can go to court for the purposes of getting an accounting, and they can remove the trustee. That's typically an authority that they are given, and we also typically give them the authority to amend the trust. Now, not, you know, turn it upside down, but, you know, if tax laws change, if benefits rules change, if there may have been an error in drafting, these are examples of the things that a trust protector is generally allowed to do. I'm going to move quickly into talking about assisting in decision making. So we're making a shift into talking about sort of the spectrum leading up to guardianship. It's very common in my experience in working with families with an individual with disabilities that parents, as they see their child approaching adulthood, want to have some legal and authorized role to continue to be involved with complex decision-making if it's possible. They want to support their child's independence and autonomy, but they also want to protect their child from manipulation, from being taken advantage of. And would like, if possible, and if their child is able to agree, to be involved in important decisions in the future. And what we're really talking about in decision making is what someone's capacity is, their ability to understand a specific decision. What decision is there here to be made? What are the variables? What are the options? What are the consequences? And so when we talk about someone's capacity for decision making, we have to look at that in the context of what decisions are we talking about. And generally here, we're looking at financial and medical decisions. And I think it's helpful to have, sort of have this visual of, of people who sort of exist across a spectrum of capacity for decision making around financial or medical matters. If your child as an adult, because they have to be over 18 to be able to have the opportunity to make their own decisions, if they're able to make voluntary, not like just acquiescing, but sort of if they're able to choose to make decisions about whom they might want to allow to assist them, if they're able to make that decision independently and in a knowing fashion, essentially informed consent, then they may be able to do a financial power of attorney and a medical advance directive. The next two slides talk a little bit about the content of those things for those two documents for your reference. What's important to remember here is that when we talk about power of attorney or medical advance directives, often I hear folks talk about, I need to get power of attorney for my child, or sometimes for my elderly parent. And one doesn't go get this power. The individual gives it. And that individual has to be able to give it in a knowing and informed fashion. Sometimes the individual isn't able to understand those concepts and aren't able to enter into legal documents of their own. And so in that situation, we have a number of alternatives that short of guardianship that help to support that kind of decision making. So on the financial side, for somebody who's receiving SSI, Social Security may have appointed a representative payee. Well, that person is responsible for looking after that money, and we don't need a guardian to do it. ABLE accounts are another example, as Kelly talked about, that the ALR for the ABLE account has authority for managing those funds. Assets that are in a trust will be managed by a trustee, and so we don't need a guardian for that to manage those funds. And these alternatives may well may operate for years in taking care of the financial aspects of public benefits, assets in a trust, and so forth, without needing a guardian. If the status quo changes, if someone comes into money from another source, an inheritance, that lottery winning, so forth, these other alternatives may not be sufficient. And so at some point in time, we may need other options for managing funds. But I would say that the majority of clients whom we serve use these vehicles like the rep payee and trustee and so forth to manage assets, and you see that as an alternative to guardianship. On the medical side, I'm just going to point out that family members by law in Maryland have the authority to make decisions for their child who is an adult and who may not be able to make informed decisions about their medical care and who don't have a guardian or an agent under an advance directive. Parents by law may have the authority to make medical decisions, get information, and so forth. And I've given you the list of these alternative surrogate decision makers and the reference to the state law there. Often families don't realize that they have this authority, and it's not granted by the guardianship court, and it doesn't require an advance medical directive. Also, it's important to remember that your adult child may consent to your or another person's being present during medical appointments or being able to get information. We often overlook this sort of basic ability for someone to express their own autonomy and say, yes, I would like for my mother or father to be able to get this information and to be able to talk with my doctors. If we have someone who is not capable of making decisions as we've described before, and we don't have these less restrictive alternatives, that's when we get into the realm of guardianship. And in brief terms, these two slides describe guardianship of property and guardianship of person. The guardianship process involves filing papers in the circuit court. And here we're talking about for someone who's over 18. It requires medical or professional clinical evidence of someone's lacking a capacity to make decisions. The court will appoint a lawyer. They'll appoint counsel for your child for what we call the alleged disabled. There will be a hearing. It might be remote like this, or it might be in person. The guardian has to undergo training and certify that they've done so. And guardianship embarks on a really lifelong relationship that involves annual reporting to the circuit court. And it's a matter of public record. The appointment of guardian we think of as a very benevolent thing, but in fact, it takes rights away. And it essentially leaves the ward, as we call them, in a permanent state of sort of childhood, that their guardian has the right to make decisions about their person or their property as if they were a minor child. So it's a pretty important decision to consider. With that, I'm going to wrap up. I've gone over, I apologize, and open up for questions for the group as a whole. And thank you all very much. I'll note my contact information is on the front page of my presentation. Thank you so much.
Thank you, Mary, so much. I'm sorry to rush. It's so much good information. I do want to have some time for questions. And I am going to, let's see, are we back with unsharing the screen? Are we back with everybody? I think, okay. So I'm going to go to the chat, and we do have a couple questions. And yes, just so you all know, you'll all receive a copy of the slides. There's some other materials that our presenters have offered, and those will be emailed to you, and they will live on our website along with the recording of this. We will have part 2 in the springtime, so I hope that you'll be able to join us for that. Let me see. So we have Sin is asking, and this, I believe, came after Kelly's presentation. So are you saying remove your child, your special needs child, from your beneficiary list? If one of the presenters would like to take that question.
I think the point there is that you want the special needs trust to be the beneficiary, not the child individually. Sorry, Kelly, jump right in there.
I was going to say, I did say that, but that's because remember that any amount of money outside of a special needs trust or an ABLE account, which are both asset protection accounts, will be counted by Social Security. So if someone leaves an inheritance and puts it in their savings account, boom, you're over-resourced. That's why.
Thank you, guys. Here's a question. We have a college 529 account. Can we convert that to an ABLE account?
Yes, if you roll that over to the beneficiary who has an ABLE account, if as long as that person's a family member, a sibling, a step sibling, they are able to do that, but they're still subject to that standard annual contribution limit of $16,000 a year. So if you had, $30,000 in a 529, roll over 16 this year and the remainder amount next year. So you kind of ladle it out until it's all rolled over.
That's great, Kelly. And a follow-up question on ABLE. Is ABLE an interest-bearing account?
It is an interest-bearing account, and account holders do not pay taxes on the earnings in the ABLE account, not while the money's in the account and not when they take it out, provided that they're using those funds to pay for qualified disability expenses, which are anything that supports the account holder in their health, independence, or quality of life.
Okay, thank you. And one more for you, Kelly. Is it akin to investing on a 401k?
Not really, because 401ks, I believe they're a retirement account. You have your access fees if you take an early withdrawal. ABLE accounts, you can access those funds at any time. ABLE accounts are special tax advantage savings accounts intended to protect the assets of the person with the disability that was made available through that federal legislation, the Stephen A. Beck Jr. Achieving a Better Experience Act. So that's how they're different.
Thank you. Scott asks, is it possible to have multiple trusts, first and third party, to have both of those?
Yep. We often see clients who have who may have more than one trust. So there's the benefits programs, SSI, Medicaid have no rules with regard to limiting the number of trusts someone might have. And we often see clients who may have a first party trust because they had assets of their own, and so they're using that type of trust. And they may have had the family may have established a third party trust through their own planning. So the short answer is yes, you may.
Thank you. Genevieve asked a question and Jim Kern actually answered it in here, but I will share it. My question was not about linking a checking account that receives SSI. It is about direct depositing the SSI directly into the ABLE account. Apparently some ABLE accounts do this, and it would be really important feature for protecting benefits. And Jim, you answered yes. Oh, you answered yes.
I was
first and
answering
third party.
more
I'm
than
sorry.
one.
It would be good if
answering-
I would read ahead. My apologies.
Yeah, okay.
Can somebody address then Genevieve's question?
Sure, I will definitely do that.
Thank
So
you.
we did receive notice from Social Security in August saying that people could make direct deposits into of their SSI funds into an ABLE account. Now, this is a person's choice. It's a personal choice. Some people say, no way, I'm not commingling funds. I want them separate. Some people say, yeah, this is convenient and I love it. It is available to do so. The question actually that the person Genevieve was asking is, how do you do that? Currently, Maryland ABLE is not set up to be able to have SSI make a direct deposit into the ABLE account because they don't, ABLE account funds are held at the Bank of New York Mellon. It's not like they have an individual checking account or savings account number. They have an ABLE account number, and Social Security can't send it to that. So we are in the process of working through this request with our program manager. It does take time. It has to go through their banking process, our legal process. It does take a little time, but please know that we are aware of it. People do want to do it, and we're going to try to make that happen. We just have to figure out the how to.
Thanks, Kelly. Heidi asked, where would a certificate of capacity be registered or submitted?
That's a document that we use internally in our office so that we have that evidence of a physician's assessment of somebody being capable of, for example, preparing and signing legal documents. It's something that we keep in the file. It isn't something that's published or recorded. I use the term certificates later in my remarks talking about the guardianship process, which does require certain specific types of certificates in quite a lot of detail from medical or other healthcare professionals as part of the filing for guardianship. So in that case, those certificates are a matter of public record in the courts.
Thank you, Mary. Another follow-up question. What if parents of adult children who do not have decision-making capacity don't seek guardianship and rely on Maryland law for surrogate decision makers?
I think that happens every day.
Okay.
Every day throughout the state.
Okay.
That is a very common circumstance, and hospitals recognize that authority without much difficulty. Sometimes in an outpatient setting, doctors' offices or other healthcare professionals may not be so familiar with that. We often recommend to families, to parents, to have a meeting with their healthcare providers before their child turns 18 to talk about, here's what we anticipate happening when my child turns 18 and we don't intend to pursue guardianship at this time. And, we expect to continue to be able to work and communicate with your staff and with you. And be happy to send anybody a copy of the statute if you need to show that.
Thanks, Mary. Can guardianship be transferred to another via a will? Good question.
That's a really interesting question. If a parent is already a guardian, and they would essentially what they can do is to nominate someone whom they would want to be their successor. Today, the circuit courts don't have a good mechanism for lining up successor guardians. It's sort of a one at a time thing. But we often recommend, pretty much always recommend to parents who are guardians to put their nomination in their will, because that we believe will carry some weight with a judge in the future.
That's great. When over-resourced, how long does that affect the child? How to correct that if that happens?
Want me to take that one?
Sure.
Yeah, you take it, Mary.
Um, most benefit programs, so the one we're talking about SSI, the income benefit and medical assistance or Medicaid, you have a monthly requirement to to be below the resource limit. They look at the end of every month. And so if you are over scale at the end of that month, you're going to be considered ineligible for the month following. And now these programs don't necessarily, they're not going to know unless you tell them. And part of the enrollment and eligibility process requires you to report on a very tight timeline. And the sort of the important message is to try to resolve this as quickly as possible and to report. Usually we recommend that you report when you fixed it. But it's sort of a rolling eligibility on a month-to-month basis. So you could be found to be ineligible for a number of months if it takes that long to fix the over resource situation.
Okay. Can money to the ABLE account be deducted from payroll as pre-tax?
So money can be deposited for a direct deposited into the ABLE account from a paycheck, only for the beneficiary or the ALR at this current point in time. However, it is not pre-taxed.
Okay, thank you. Another ABLE question. Does interest accrued count towards the $100,000 limit in an ABLE account?
It does.
Okay. I hear $2,000 limit in order to continue SSI benefits is for child under the age of 18. What if the child is over 18? Do the same rules apply? They do. Okay. All right. And you did answer that in the chat. Thank you, Kelly. Do you need to set up a special needs trust with a lawyer or financial planner? Does it get filed in court or to the state of Maryland?
An attorney, not your financial planner, will write the document.
Okay.
And the filing in court is going to depend on whether court authority is needed in order to set it up. But it's not something that's routinely filed in a court. There's no sort of publication requirement of that nature. There's a certain type of trust, the first party aid type of first party trust, that's somebody's own money going into the special needs trust, certain type of trust which has to be approved by the Maryland Medicaid program and which requires an annual filing of accounting to the state, but that doesn't apply generally to third party trusts at all.
Thank you.
Melissa, I just had something I wanted to add to that, and I've had the opportunity to talk with families around the state. And a lot of people ask that question about who they need to see about special needs trust. I recommend that they see an attorney that specializes in estate planning and, elder care law, people that specialize in working with families with disabilities, because it's very nuanced. Okay. And you don't want your neighbor's friend's brother who does divorces, car accidents and whatever to set up a special needs trust. They don't have the very important knowledge that they need. So please think of that.
I want to underline how important that is, Kelly. And it is, people don't know what to do. Monty and I get asked all the time, can you do the special needs trust for us? And it's, well, no, An attorney has to do that, and an attorney that, as you just said, that's what they do.
Yes.
On the resources page in my materials are a couple of websites that could be helpful in finding people. One is the Special Needs Alliance, which is a national organization of attorneys who do this kind of work. It's kind of a small group by invitation only, and we have people throughout the country. There's also the National Academy of Elder Law Attorneys, and people who do elder law often do special needs planning as well, because a common theme there is public benefits eligibility. Both of those websites have a search function to locate attorneys.
Thank you, Mary. That's great. I didn't know about that latter one. That's good to know. Great. I think that's all the questions we have in the chat. So I want to thank all of our presenters. I'm sure everybody's head is spinning. It is a lot to take in. That's why we're doing this in 2 parts. This is kind of, think of this as kind of a big overview, and we're going to be digging down a little deeper in the springtime. Please complete the survey that comes out. Let us know when you'd like to do that. We'll try and get these materials out to you, hopefully by the end of the week, so that you can look over them and have them for your records. And again, thank you to Jim and Monty. Thank you, Mary. Thank you, Kelly. Such great information. And we really appreciate you being here with us tonight and helping our community. So good night,
Thank you so much.
everybody. And we look forward to seeing you. Next month, we will be, our speaker will be Mary Ann Kane Bresci, talking about charting the life course, which will be another great conversation for anybody, you know, those of us heading to retirement or wherever you are in your life, and the life of your loved ones. So I think it'll be really terrific. So thank you all very much.